Okay, is Gia here? Gia is here. Want to formally introduce, thanks to the good offices of the law school, we have a formal teaching assistant, Gia Lang, who's in the right-hand corner and is going to be helping on the digital media project and on the course generally. Gia is originally from China, is a Chinese MMO player, and some of her insights on international issues and MMOs will probably start taking a serious part of talks 7, 8, 9 as we deal with regulation and those sorts of issues. Thanks to everybody who has been posting on the blog and following it. As of yesterday, we have one more development on the blog, and that is that if you Twitter and you add the hashtag UBCVGL to anything you tweet or retweet, it will go into the widget on the blog. So on the right-hand side, you'll see @GameBizLaw, which I'm directing entirely to you guys. So there's an @Jan Festinger, which is more general, but everything I'm putting at @GameBizLaw is for you optionally. Below that, you'll see another Twitter input and feed, and that's for the hashtag @UBCVGL. Rock's been using it, but it is for guests of the class, it is for students, it's for all of us. If you see anything interesting, feel free to use it. Also, in that regard, just want to encourage everybody to use the blog site, and there have been some incredibly thoughtful and long and excellent posts, but don't feel that you have to put up something necessarily of that length and depth. If you've got if you've got a short take on something, please stick it up there. Last night, got an email saying, put this article up, and I did. Not everything has to be long. Okay, second hour, we are going to have Jazz Purewell from Osborne Clarke in London talking about international video game law issues. That's why you see this wonderful live boardroom in London. I think he's in London. He may be in one of the other offices of that firm. So we're going to have a bit of a split screen, and we can talk about, do you guys all know how to use the microphones? You hit the button. If somebody else hits the button if there are two simultaneous buttons, the first one will get to talk, the next one will flash, and as soon as the first person turns off their mic, the second one will go. So hopefully we can have a really interactive session. Any questions about the class? Any logistics that anybody wants to talk about? Okay, so today's challenge, the whole first part of the course was getting us to focus on creating and to understand the modes of creation and what it looks like in a video game sense, and what it feels like even. Now we move to how you connect. So you've got a creative product. How does that connect to the world? And in essence, we're really bridging to contract law. So we're moving in some ways, as you'll see, from free speech, free expression, to what happens to that speech and expression, and the role that contracts has taken in spreading video game culture and video games themselves. So that's what today's about. Last week was a bait and switch. Was trying to get you focused on the right to mod, right to create, what the real messages were, was the relationship of free speech rights and copyright, and whether copyright can be said to be derived even from free expression. And an important notion that we're going to focus on, we've talked about it a bit, but we're going to focus on it the rest of the course. Pardon the bad video game joke, but leveling up. Do video games exist at a different and higher plane than even other forms of interactive media when we look at intellectual property issues, and even when we look at contractual issues? And how do they relate to more two-dimensional, less interactive media like television and radio and film? Then there was the attempt last week at creating a symmetry, and hopefully I've labeled it a little bit more clearly today, and that is the notion of personal interactivity in a creative environment, which is very much a video game modality, and then switch the words around. I'm sorry, personal interactivity in a creative environment, which is video games, and then switch the words around, personal creativity in an interactive environment, which is more web social media. And then, is the right to mod the same as the right to machinima and the right to remix, or does it live at a higher level? These are the questions to ask yourself as we go forward. So, you would certainly know that the creative can be seen as almost a sacred right. That's certainly been a theme of the first 3 classes, and also in that regard, that may tie into moral rights, or the usefulness as moral rights as a model to solve some of the more difficult problems. Just wanted to show you some art from a great Vancouver artist and friend of mine, Alan Switzer, with his permission. And you can see the mixed medium of photographs from other times with current art and various layerings, which is very much his motif. You can go to his website and see lots of that stuff. So today we move from creating to connecting. And there's a couple of quotes, and again, all of this is up on the blog site by this evening. And they all go to what connectedness really means, and that creativity is either completely reliant on the notion of connection. Is a creator without an audience the sound of one hand clapping? To probably mangle the Zen cone. Do you have a creator without an audience? And for our purposes, what difference does it make? Because you don't have a video game without both a creator and a player. Find me a game without a player. Now that may go to some of the things Tyler's blogged about and some of the things that have come up as to what the next world looks like. Please.
That fantastic movie in the 80s, War Games, where the computer plays itself.
Yeah, right. But that's a really great point. And the other thing, obviously, is we can all go, and I'm stunned by seeing how much time my son spends on YouTube looking at gaming playthroughs or gaming competitions. But actual video gaming requires both. Otherwise, it's a form of television. It becomes passive. So the game, the play component, very much takes us there. The Edward de Bono quote is an attempt to add some academic gravitas, that without creativity we would forever be repeating the same patterns, meaning creativity is intrinsically connected to change in an interconnected sense. And it's well worth going to the interview just because it's from 1996. Wired interview with Steve Jobs from 1996. So it's a time machine, pre-iPod, where he comes up with the very famous quote, "Creativity is just connecting things." Einstein, a different take, but basically the same message. Now we get to something interesting. I hope. Hope it's all interesting for you to judge. Have purposely not included the name of the person who made the top quote. And it's a very appealing quote. The creative is the place where no one else has ever been. No one else has ever been. You have to leave the city of your comfort and go into the wilderness of your intuition. What you'll discover will be wonderful. What you'll discover is yourself. This is a Hollywood actor, writer, and producer. And I'm not being critical, but I want to show you something, and someone I quite like and whose work I quite like. But I want to show you the contrasting model to interconnectedness. It's the view that creativity is a uniquely personal experience. And it's yours, and it's all yours. And it doesn't really belong to anybody else. And these are very contrasting viewpoints in the world, of the world. Creativity is just connecting things to creativity is something unique about me. Totally different. And thanks to Ken, we've debated large aspects of this previously in the course. Two things. Most of the research, and it's not definitive, but most of the research, most of what seems to be out there, does tend to support the notion that creativity is a product of interconnectedness and that our ideas all come from somewhere else. And even if Einstein says it's contagious, pass it on, and kind of goes to a bit of an open source place that way, when arguably he saw some stuff that nobody else saw. That's a pretty strong endorsement. So where does this come from, this notion that I identified perhaps unfairly with Hollywood, that it's really me, I'm really different? Well, it's really deep-rooted in our mythology. Go right to Genesis, go right to the Bible, and go to the first mythological act of creation. And God said, "Let us make man in our image, after our likeness." Deeply personal. I've created something, and it's like me, and in fact, it is me. Okay, so pretty clear. If you're looking for an alignment, then if you're tending towards copyright literalism, you're more likely to believe that creativity is a uniquely personal experience. If you are tending towards seeing it as all interconnected, then you're more likely to be an open sourcer. It's not a matter of who's smart and who's not so smart. It's really a matter of how you look at yourself and how creators look at themselves, whether they feel that stuff is passing through them or actually belongs to them. And then it becomes pretty easy to project that onto the law. Zohar, I'm going to come to you in a second. The point being that the Hollywood model is a form of self-fulfilling prophecy. It should not be surprising to you that the film industry, especially the film industry, is contrasted. The television industry has adapted itself more to new media, I would argue, than the film industry. But that auteur mythology lives very strongly in the film industry, lives very strongly in Hollywood, and that's why I include the quote. Not to mock it, but because it's one of the best examples of its kind that I could find. Zohar.
I'm just wondering if you'd agree that maybe there's a distinction between the creating process and then the fixation, in the sense that, like, if you view creativity as interconnectedness or as something that comes from inside the person, whichever way you want to look at it, you're talking about the process of creating something. But then the fixation, once it becomes fixed, then at least in my mind, I see that I could understand why a person who even views it as being interconnected and they're just bringing things together, once they've brought those things together and produced something, they may still feel a certain kind of,
I think that's a fair distinction, and the metaphor would be, I found this oil in the ground, and therefore it should be mine. It doesn't actually belong to me. It actually belongs to the earth. These are very large, almost metaphysical questions as to where you draw the distinction and where property begins and where it ends. And there's a paper that I'll refer you to in the context of the talk today that hopefully you can read and will take you part of the way there. Just very quickly, the current question, the current sort of pseudo-academic and academic debate around these issues of creativity, at least for the moment, seems to be centering on the power of introverts, which is a kind of a popular meme out there that introverts, being an introvert is a very powerful source of creativity. When you look a little bit deeper, and there's a Keith Sawyer piece, Does Solitude Enhance Creativity, that I would really commend to you. When you look a little deeper, the introvert theory actually in no way threatens the interconnectedness theory. It just basically seems to say that introverts have a facility by tuning things out to tune all of these diverse interconnected sources in better than the rest of us. So it's in and of itself, it's a little bit of a bait and switch. Then terrific blog by Nina Paley, which none of these things will take you long to go through. All creative work is derivative, speaks for itself. And a fantastic, you must go to at least Stephen Johnson's TED Talk on creativity, which focuses on the role of the English coffee house as a nexus point for creativity in previous centuries, and how it is, in a sense, a precursor of what we're experiencing in the web-based world.
Can I suggest another?
Please.
Rudolf Wittauer wrote a book called Born Under Saturn with his wife a number of years ago, basically talking about the role of genius amongst painters and artists in particular. It's a sort of standard book, again, celebrating the central role of the individual creator, artist,
Yeah.
and where they might be. And in it, it examines a lot of the sort of questions as to how much interaction there would be. The Italian Renaissance, for instance, being one where you had a large sort of critical mass of artists working, able to sort of spark off of each other, and comparing and contrasting that with other lonely individuals who were the romantic notion of the artist being the outsider in society who is able to sort of come forward with viewpoints that the rest of society is unable to see because of their isolation.
And if I can add two more sources that have been mentioned either in the materials or previously in the course, but you'll find them on the syllabus, which is on the blog. Joanna Blakely's piece on fashion, which is a TED Talk, and Bruce Springsteen's absolutely awesome SXSW audio speech, which I commend you have on in the background because it's riveting. This is just a nice piece that I found. This is a remix, it's wonderfully filled with all the right ironies. This is a remix of a quote by Ralph Waldo Emerson: "To believe what is true for you in your private heart is true for all men, that is genius." That was the Emerson quote, remixed: "To believe what is true for you in your private heart is true for all, and then make something about it for all to see, that is art." So Wendy Mack, that makes several points all in one slide. So what does this say about video games? So I get you into this interconnected space, thinking about the importance of interconnection. Why? Because video games are probably right now the very best example of mutually reliant and merged creativity. More so than anything else that's going on out there, in my opinion. But please challenge that. There's lots of places to go with this. But you need both the player's creativity and the game creator designer's creativity to have a video game. And so it becomes a perfect lens through which to examine these questions. The problem is, and this is a problem for you guys to solve as you move forward in your careers and your lives and in what happens in the next 20 or 30 years, whether video games are too perfect a lens. Whether you can say, oh yes, there's a perfect alignment in video games that makes it different from everything else. So there is a way of deconstructing this so that video games indeed are on a higher plane or at a higher level, but might end up with rules uniquely about video games and video game creativity, and harsher or rules that are less intellectual property, and even contractual rules that are less about interconnectedness could still prevail with respect to other stuff. Too early to tell. We don't know, but the possibility needs to be acknowledged. And the question is, are video games going to be the exception that proves the rule, or are video games going to be the leading light which helps other digital media to a place of, I guess, in my view, greater freedom? Others may see traps in there. So where does this go? The Hollywood personal genius theory gets undermined by something fascinating and something deeply ironic. And something that doesn't really stand up very well to the double standards test. And that is that if it's really personal genius, then why is the threshold for copyright so low? And why, even for patents, in a different way, is it so low? And so this, Zohar, this is the paper I was referring you to. Terrific UK paper, The Innovation Dilemma, Intellectual Property, and the Historical Legacy of Cumulative Creativity. And this is a paper trying to look from a UK perspective about how they should move forward. Should they incorporate fair use in their copyright law? Shouldn't they? All the issues that we've talked about, but a fairly fresh look. And here you go. One of the things that the authors, who are legal academics and law, who teach in a law school, wonder about is whether the creativity bar should actually be raised in an interconnected world. Not gonna, you can go to this, you should go to this. Very useful for your own papers to think about. But I want to move on. You will have noticed I have a tendency so far in this course to talk about copyright law and patent law. And I don't mention trademark law very much. And we're about to get to why. But before I bridge there, questions, comments, ideas? We're all good?
I've got one comment.
Please.
When you're talking about, it's something you can't avoid, when you practice, and in my case, when people find out I practice patent law, it's amazing how upset they get at parties when they talk about patents. very, very disconcerting. And you're standing there with your drink, and you're trying to relax because it's Friday night, and you looked at patents all week, and you don't really want to talk about patents, but for some reason at this party, people want to talk about patents and how terrible they are. And usually the point is they're dumb, you don't need them, get rid of them entirely. But I think what people are really thinking is what you were saying in the last slide. It's not so much the concept of should you have copyright or should you have patent. It's what's the standard you have to meet before these rights are granted. Is it original enough? Is it inventive enough in the context of a patent? A lot of articles in the news focus on software patents and trolls and how we change the law. arguably you don't have to change the law at all. Arguably, you just have to enforce the laws that are already there in a way that's not being enforced. A big problem is a lot of the patents that are granted, well, all of the patents that are granted by the U.S. Patent Office, where the people who grant them aren't lawyers. They're people with some technical expertise, but they go in and they try to apply very complex laws in ways that aren't that successful, which can cause a bit of a mess. So, I would agree with John that it's the threshold that I think is the key issue, more so than should the laws be there.
Well, fits directly into where we're going to go. So yes, enforcing the law as written is one thing. Trademark law has a feature which perhaps can be adapted to copyright and patent law. Again, it's a theoretical point, something for you to think about. But trademark law is use it or lose it. It's the most, there's a genius in trademark law because it is really tied to commerce. And it's completely, because it's tied to commerce, it's tied to use. And if you look at the provisions of the Canadian Trademark Act, and you look at the regulations, and you look at the forms, you'll see a pretty consistent string of, if you're not using your trademark, you will lose your trademark, and others could remove your trademark. So you must be using it. It has a built-in mechanism to prevent trolling, to prevent people sitting back with a piece of intellectual property. And it's a very simple mechanism. And it really would prevent people from sitting, you're actually, literally, if you sit back and go, I've got the trademark to Coca-Cola, nobody can use that, and it's going to be valuable to someone, you can't sit back and not use it. You lose. So it's a really interesting mechanism, and it's worth wondering whether it can't be adapted in some way to encourage not only innovation, but the practical application of innovation and it coming into the world if it's going to be protected at all.
I feel like patents can be used defensively, and that's quite reasonable. They're fundamentally different than trademarks.
Mm-hmm.
You're wanting to push, say, one lead compound as a pharmaceutical or something, so you patent everything also around it, so your competitors don't get to compete with you. And you're not using it, but it's in use as a block.
Right, and so there's there's kind of the chess go theory of intellectual property. You can use it. You're in a sense saying don't use it as a sword, but you should be able to use it as a shield and use it tactically. And that's a perfectly viable point. The issue here is where on the continuum do you want it to be? Not saying the argument is right, but not saying the counter argument is right, but the counter argument is if there's an innovation out there that can make the world a better place, why do we lock it away for any period of time? Some of the greatest innovations that have benefited man the most significantly have been complete flukes that if they were buried under a bushel would have retarded our development. I give you the Post-it note. The Post-it note was not an intentional invention. It was a byproduct invention. Maybe more seriously, there is an amazing book by a great scholar by the name of Daniel Borstein called The Discoverers. And it is a history of scientific discovery. And there's a chapter right at the beginning, either chapter 1 or chapter 2, about the discovery of time. which is really fascinating when you think of time as a scientific discovery, but of course it was. And without time, it's shocking how many things in the world we wouldn't have. And key to our development as a culture, Borstein argues, was the invention of the clock. The clock begat all sorts of other things. And even, to some extent, begat the Industrial Revolution. What has been found is that in the, I may have the century wrong, but in the 8th or 9th century in China, the mechanical clock was invented. And the inventor went to the emperor, and the emperor thought it was fantastic, and the emperor wanted to have the mechanical clock, and they built this building, and it was quite large at the time, to house this giant mechanical clock, and it worked. And only the emperor and the inventor knew about it. And it never spread. And the emperor died, and the clock fell into disuse and disappeared, and nobody knew about it. And the mechanical clock was reinvented in Europe many centuries later. And the implication of Borstein's work is to wonder aloud, gee, what would have happened if the emperor had said, this is fantastic. Let's go into the clockmaking business, and let's make sure that people have clocks and they can set the time. They're going to be more industrious. They're going to know where they are. It's probably going to have all sorts of good benefits on our crops and whatever else. So there's a deeper story. Look it up. I have not cited it anywhere. It's called The Discoverers, Daniel Borstein. It'll be chapter 1 or chapter 2. And read it for yourself. But it's kind of a profound take on what we should or shouldn't do with patents. And again, I don't think there are absolute answers here. I think it's a continuum. Please.
Timing's off. The Greeks had a water clock for timing the length of time that you could speak to the ecclesia, at least 500 BC. There have been clocks around for a very long time, mechanical clocks, which measured time and specific amounts of time. There's also been astrolabes. There's also been all sorts of observation tools for...
And sundials forever.
All sorts of things.
And Borstein gets into it, but the actual kind of windable mechanical clock.
Even a windable sort of mechanism, we have several of them that have been found in archaeological sites and off of some of the ships that have been excavated in recent times in modern archaeology, going way back. The fact is that these inventions sometimes are known, sometimes are not. They come in and out. One of the advantages of a patent system has been that it calls for inventors to share with the rest of the world or whoever what their creativity is in a working manner. They have to be able to describe what their invention is in a way that would allow somebody else to make it and have it work the same way.
So that's really...
That's the incentive, that's the justification for the bargain of giving anybody any patent time.
But that is
very different from the bargain that you do for trademark, and it's very different from the bargain that society does for celebrating the expression, the expression of ideas to other people, which involves communication. There are 3 different kinds of bargains being made here from a utilitarian justification for intellectual property rights. And it's a little bit, trademark can go on for as long as you continue to use it, as long as you continue to control it, and as long as you continue to pay your dues, like your fees, on a regular basis. And it will go on for that amount of time. But it's an incentive that's invented basically for consumer protection. The idea that the people in the marketplace should know who is the source, where the manufacturer of the goods comes from. it doesn't reward creativity other than you've established use of that particular mark. That's a very different thing from rewarding somebody for giving you a working model of their invention. And if you're going to encourage a wide variety of people to show off their inventions, you're going to encourage a lot of inventions that are not going to be very usable.
Well, let me interrupt you to sort of make 2 points. First, I think you'll find if you go to the Borstein book that all of these incremental steps are well documented. And whether he's right or wrong, and whether my reading of him is right or wrong, he certainly sees something quantumly different in mechanical, in this version of the mechanical clock. And it makes for a great story. But the really profound point you raise is we can read that story in 2 ways. One is to say, well, gee, don't hide it under a bushel. The other way you could equally read the story completely correctly is, here's why you need a patent system, because had there been a patent system in China, this would have gone into it, and at some point in time, rather than being literally buried in the dust of history, because they found this through an excavation, it would have been documented. Maybe nobody could have used it for some period of time, but it would have been there and would have been the base for further innovation, which really is Borstein's argument. So I think we've had a good discussion on trademarks. But now, remember, we're trying to bridge to contract law. So we've we're ending our dalliances with IP. And the question and the alignment and the symmetry that we want to focus on, and I'm pretty confident about the first part, that creation goes with copyright and IP law, and that almost suggests that connection goes with contract law. But it's not, doesn't feel natural. Just putting it out there for you guys to think about, because in some ways, that's really what's happened. And I wonder if, for the rest of at least this talk, we're going to be proving something that's a false proposition. But it may be a false symmetry, but that is how the real world is lining up, for better or worse. So that takes us to, have we completely wasted our time for the last 3.5 talks? Does IP really matter in a world where you're just saying I agree, and whatever you say I agree to, for the most part, I'm not saying it's completely unchallengeable, but for the most part, constitute the rules of the road for all of the relationships around and through and about that IP. And that IP, that copyright law, that patent law, trademark's less of an issue, but it's in there somewhere, recedes into the deep background, and the contractual relationship between you as player gamer in our mode and the game creator, developer, distributor constitutes 95% of all you have to know. And then, for the next little while, we're going to talk about questions around what that means. Zohar.
Yeah, I think I said this in one of the last classes, but I don't see how you could have a meaningful contract without IP in the background. I don't see how you could, there's no incentive to sit down at the table with somebody unless they have a gate that says, you don't come through this gate unless I let you through the gate. Then we talk about how much it costs.
I agree with you. I'm not saying IP doesn't exist. I'm saying that it's moved to a plane that doesn't affect 99% of us 99% of the time, And in the world, 99 or even more than 99% is a lot. And from a public policy perspective, from a law and justice perspective,
But doesn't it?
which I'd like to think is why you're here, the fact that the IP, which is in the deep background, casts such a large shadow on the contractual terms in the foreground, which people agree to basically through some form of contract of adhesion, like it or not, that should raise questions to you guys.
It just brings to mind, you know, we're talking about video games. So 99% of what happens in video games has been coded in a language I don't see when I'm playing them. And it's been done behind the scenes, right? And the consumer, generally speaking, is most likely going to be faced with the final version that's been cleaned up after a lot of work. So the hard work and the heavy lifting and everything else never gets seen in the public in almost anything we do, right? So that's why I don't know.
Okay,
I'm just
well, let's.
pushing back on it.
I'll come back to that, but maybe we have some other
I'm
answer.
with Zohar on this one because, I mean, an analogy with the building that we're sitting, right? Tons of work has gone into the regulations on building codes, what materials can and can't be in it. 99% of the time, you're not going to worry about buildings like this falling in or collapsing on you or having some problem like that. But you want to make sure that the fundamental work has gone into it. Now, it's definitely a little bit different when you're talking about things like copyright and IP. You're not going to literally have that fall in and kill somebody, I hope, I trust. But at the same time, you do still have the fundamental underlying pieces that can be very important to the rest of it.
Yeah, I don't think there's any dispute, and I don't think there are absolutes here. I think there's just, you know, different perspectives and a balance rebalance. The partial answers to what you're talking about are that games today, video games today, tend to be massively multiplayer, which is a big factor, tend to be open world, and you never, as a gamer, have the same experience twice. So yes, there's a lot of work into the space, and there's a lot of work that went into this building. But how would you feel if this building asserted property rights over what you're doing, what you're thinking about, what you're building, the business plan that some of you are doing right now about building this widget or that widget or what your project's going to be. Not all of you are going to go to law firms. Or asserted some right, some carryover right onto your income when you do go into a law firm. There are no right and wrong answers here, and I don't want to pretend there are. But there are right questions, and you're asking them. So let's keep going. So
the one thing I'll add to, let me just jump in, is, I mean, the subtext here, of course, we're talking about video game law, where necessarily you're licensing a piece of software. So to use the product, you have to agree to some kind of license. And we're practically, with so many, every game is online, so whenever you play one of those games, you are forced by contract of adhesion to agree to something. So in this context, contract is everywhere. But let's not forget that, I mean, if you want to analogize to the whole world, I don't think it holds. I mean, you go and you buy a drug, there's no contract, but clearly, if you want to make a case for IP affecting an industry, the pharmaceutical industry probably affects that more than anything else.
Well, we're going to, in the next 10 minutes, we're only going to be talking about questions, not answers, that are raised by this. But just one small piece of trivia. If you look up freedom in the dictionary, one of the meanings is license. I find that fascinating. In any event, no, it's not swept away, but what's pushing IP to the background? Licensing agreements, privacy agreements, to some extent other stuff is having that effect as well, because it exerts influence. So here's the question. How come, not that there are that many stores where you can buy a CD of music, but there are. If you go into a Starbucks, like how distribution has changed is mind-boggling, and buy an album, if you go into a Starbucks and buy an album and stick the CD in your CD player and listen to the music, have you signed, agreed to any kind of license agreement?
Yes.
Yes?
I mean, you.
Yes?
Well, there's like terms that say you can't illegally copy this and sell it.
Where are those terms?
I'm assuming they're in the CD somewhere.
They're not. They're in the Copyright Act.
Okay.
They're there by statute. Intellectual property law comes into the foreground in that situation. There's no, now, there may come a day where to stick it in, there's a DRM system that makes you go to your computer to click I agree. But it's a different experience than when you go onto iTunes and you, I think we're on iTunes 11 now, that's an old picture, but when you go onto iTunes and you've pre-agreed to certain conditions. So it's very interesting because it's the same music, and you may even be listening to it out of the same device, your computer. One's got a CD, one's streaming through iTunes. Interesting. So why does this happen? You have to understand that the software industry wasn't about video games originally, and Ken can probably, take us through this much better than I can. But it really started in sort of enterprise software, accounting software, and in very particular applications for particular companies. And it wasn't a mass medium. You weren't reaching hundreds of thousands of people. It was a small consulting firm of what we would today call hackers, working with a company. And there were all sorts of good reasons. They were the little guys to make sure that they had control over the program, including, very significantly, maybe the best reason was quality control. You didn't want somebody in the accounting department to start fooling around with your software and wrecking all the work you've done. Very different reasoning from mass entertainment modalities. The other thing that facilitates all of these contracts is that intellectual property is infinitely sliceable and diceable, and that's part of its genius. I can license you something, I can split up the world, I can split up time, I can do any trick I want with contract and license something to you for use while you're standing on your head every second Tuesday of every third month. And as long as I've got my rights straight and my rights table straight, I can split it up, and by splitting it up that way, I can increase the value. And I can never sell the same thing twice, but I can really increase the value by fitting very specifically to my audience. I can give you what you need, and I don't have to give you more than you need, and therefore I can keep it for myself and give it to somebody else. And that just creates value. So there's a lot of very positive, positives about it, which makes IP very, very contract friendly. And that's where we get our contracts from. So now, I promised you a couple of minutes of questions, and these are just questions, and we're going to focus on these for the next couple of weeks in different forms. This does create the chasm that we alluded to. The first piece is actually an academic, it takes you to an academic article that if you extrapolate the numbers that they did. It's a 2008, so it's probably way more today. It's a 2008 article, I believe. Just to read the privacy policies in 2008 that you clicked on, if you were going to read them, actually read them, would take you a month. Now, if you're going to add to that end user license agreements, move that from 2008 to 2013, and just kind of extrapolate their numbers, you would literally 9 to 5 be reading agreements probably for 4 or 5 months of the year today. So there is a disconnect here. What to do about it, how to treat it, whether it matters because all these contracts say the same thing, or do they? I don't know. Have you read them? That's the problem. Now, just because this implies the click wrap issue, BC case, recent BC case, which Rock was kind enough to send along, the Century 21 case has a good review of click wrap authorities and does uphold the terms of use, but they're in there. So if you decide you want to do a paper on click wrap, depending on where you want to go with it, it's a very solid starting point.
I'm not sure people read any contract they sign typically unless it's something truly important. Like, I mean, I doubt many of us read our cell phone contracts line by line, or renting a car. I don't think this is unique to privacy and user license agreements.
As an old guy, I'll tell you that what you will read is your mortgage. You might read your car sale contract.
Car rental, if you remember first year contracts.
Better not to read those.
Well, that's the point, though. This is one of the whole things, is it comes down to a question of enforceability. Most of the time, we all can get away without reading all of this stuff because it's not going anywhere. But if it goes to court, you can bet that your legal representative, or if you're representing somebody, you're going to be reading every word of the damn contract and of the EULA and of any of these other sorts of things that are involved to see whether or not it is standard contractual, or if they have hidden details within the contract that a reasonable purchaser would not anticipate. And that's a very important part, because most contract law works with boilerplate. Boilerplate is the shorthand that we all agree upon. So you read all of this stuff with archaic language that only us lawyers know the magic words, what they mean. But essentially, as long as things don't deviate too far from the boilerplate, you're fine. So with the EULAs and with the, the terms of service, that's sort of where some of the protection is. But the enforceability is not a given, which is one of the reasons why the industries that are interested in the old copyright business model are insisting on trying to maintain those protections, statutory protections, so as to bolster the enforceability of the contracts. Because you can sign anything you want, but what happens if there's a breach contract? Is it worth taking somebody for $17 CD and insisting on a
well, and there are also some big holes that we'll be discussing in subsequent classes around who's covered by contracts and how they're covered. So yeah. I want to get to Jazz, who's in the background. So let me just finish this off. So the next issue that we're going to talk about at some point is digital resale. There's a case going on right now, Redigi. And it goes to, okay, you have a CD, you can resell that to me, and there's laws that protect that. Can you sell me your iTunes songs, which you've probably paid more for, or as much for, as you have for a CD? That's what the Redigi case is about. Then the contracts that you sign, this is from the World of Warcraft end user license agreement, just to show you that the drafting tendency is to throw in everything but the kitchen sink. This issue came up on our blog. Death. What happens Well, if you actually read many of these end user license agreements, you will see you don't have the right to bequeath your digital music archive. Should consumer protection or other legislation intervene, what's the right balance here? You can sell your books, but the stuff on your hard drive doesn't necessarily go in the same way. Not right now going to get into the non-circumvention issues. Rock got into them in the context of other cases earlier in the course. But the digital locks issue stayed in the Canadian Copyright Act. And Michael Geist at U of Ottawa Law School led a charge to remove digital locks. And there's lots of stuff, if you're interested in the subject, out there, much of it authored by Michael Geist, and well worth reading. And where does that take us? That takes us to a world where some video game companies include the tools so that you can create in SDKs. Microsoft Flight Simulator did that for years. Said, here are all the tools. Create an industry. You can even charge. The Creative Commons movement, our blog site has got a Creative Commons license on it. The open source movement, and crowdsourcing. But all of these things, you see, we've moved the markers. All of these things are still done by contract, by license agreements. Other answers, consumer protection laws, international standards, anonymous and hacktivism, you know, the more rebellious, well, more than rebellious, often illegal forms of protest, and a very optimistic, very nice piece from a student at Harvard circa 2008 or 9 about how video game publishers are embracing user-generated derivative works, really talking about machinima, and everything in it is accurate. Isabel Arvers, who came to the Center for Digital Media for a term and was a colleague, and is the world expert, I think, on machinima, and knows an awful lot about machinima-related law, would tell you if she was here and she gave a talk to my class at the Center for Digital Media, that the contractual complexities of machinima permissions are mind-boggling. And yes, in theory, there's a friendliness to it, but in practice, it's very, very hard for creators to know what they can and cannot do. And please, in your papers or otherwise, your suggestions on these conundrums are welcome. Next week, we dig into specifics. Going to try and pull out cases and clauses, and this will actually look like a law school course, at least for 1 week. Thank you very much. Jazz, are you there?
Hello.
The forum is all yours. I'll get to a place you can see me. Hopefully somehow we can pan to the class. I'm not sure. Dan, how do we get it so that we can pan the camera onto the class so Jazz can see the class? And Jazz, I'm going to pull up